Good morning, friends, colleagues, juniors, and seniors. How is everyone today? I'm here and I'm back again. Today's topic of discussion will be on law and strategic human resource management. I repeat, today's topic of discussion will be on law and SHRM. And here I have to admit, although I'm a qualified lawyer, but I'm a non-practicing lawyer. I'm not a lawyer. What the lecture is based on a layman's version of law and SHRM. Although I'm a lawyer, qualified lawyer, I'm not practicing for a while. It doesn't matter. We are not specialists. From that perspective, I'll be talking about law and SHRM. Whatever we do seems to be related to law. Law is very fundamental or alignment of the company and law. That's where we come into the picture. Our role as SHRM specialist is to actually strengthen the alignment of the company to the law. And as far as human resource concerns is, I'll be only talking about human resource and the law. I'll not be talking about the financial aspect of law, no, or audit, no. Only human resource management and law. That's my domain, that's my boundary. I'll stick to my boundary. And our role is actually to strengthen the alignment of law and human resource management. It is to some extent our role as SHRM professionals is to accommodate law into the enterprise. It's just a matter of compliance. Enterprises have to comply with the labor law of the country and at the same time comply with international bodies like ISO. Oh, sorry. We have to also comply with the law of the countries, and also we have to comply with organizations like ILO, which is called International Labour Organization. Even compliance to ISO is essential these days. ISO stands for International Organization for Standards. It's now an extremely significant to compete in the real world, in the real business world. The ISO was formed in 1947 on the 29th February and has its head office in Geneva, Switzerland. This is about ISO, an extremely significant and powerful body of standards. ISO is very well known, is a very well known brand in the world of standardizations. ISO covers all aspects of technology and manufacturing. Now, coming back to the compliance issue, each country has its own labor laws or employment laws. For example, in Bangladesh, we have the Bangladesh Labor Code of 2006. In the UK, the law exists very strongly in different, in different acts and statutes. Actually, every country, as I understand, has in place employment or labor laws. This is not the issue. The real issue is, are the laws being implemented? What happens to the enterprise and the entrepreneurs for not complying with the labor laws? What happens if something happens or something goes wrong? For example, in some, for example, a breach of human rights or the Health and Safety Act. What happens then? These are very significant questions to ask. Even compliance, the key question is how strongly are the laws implemented? I repeat, this is the key question. How strongly are the laws implemented? In countries where the corruption is high and compliance to corruption is more important than employment law remains only in documents to a good degree. In countries, I repeat, in countries where corruption is extremely high and compliance to corruption is more important than the compliance to the labor law of the country. Labor laws of the country are only in document to some degree. If something goes wrong, that is the real test. Even to start a business requires compliance to law. Law seems to be everywhere. The domain of SHRM largely backed by employment or labor laws. What could be the elements that I'm talking about related to SHRM? Recruitment and selection, promotion, transfers, demotions, salary, wages, terms and conditions of employment, discipline and grievances, discrimination, performance and performance appraisals, equal opportunities, health and safety, harassment and bullying, trade union, industrial injury, the office or manufacturing premise, holiday entitlements, working hours, rest period, codes of practice, contractual arrangements with customers, the contract papers, breach of contracts, and so on are covered by law. I repeat this again. The domain of SHRM, where actually it is really linked to law, recruitment and selection. You might ask me, how is recruitment and selection related to law? Yes, this is about discrimination. We cannot lawfully discriminate somebody. Even in advertisements, we have to be very careful when we advertise. We cannot use any discriminatory words. Recruitment and selection, promotion, transfers, demotions, salary. Salary is an entitlement, remember that. Wages is also a right and an entitlement. Terms and conditions of employment, discipline and grievances, discrimination, performance and performance appraisals, equal opportunities, health and safety, harassment and bullying, trade union, industrial injury, official, the office of the manufacturing premise, holiday entitlements, working hours, rest periods, codes of practice, contractual arrangements with customers, the contract papers, breach of contracts, and so on are covered by law. The law of tort, law of contract, whatever it is, it's related to law. Merger, also, I forgot to mention mergers and acquisitions, insurance cover, if applicable, and so on. The main issue is Can we as HRN professionals demonstrate some knowledge of legislative framework and industry standards? Take, for example, the British Standard Audit or the ISO 9000. Each country has their own labor law and standards. Most employment laws cover the following areas: immigration workers, contractual terms, rights during employment, termination of employment, discrimination, business transfers, collective rights, health and safety laws. Some key areas of law, some key areas of law, some key expressions. For example, reasonable duty of care. This is a legal expression. I repeat, reasonable duty of care, applicable to the employers and at the same time to employees. I'll explain that within a few seconds. Background checking or references is also very, very important. I repeat, background checking of the employees or references is extremely important. The vetting system of how employees are recruited and selected is extremely important. How we vet employees by taking references, by taking valuable, relevant documents from the employees, checking out the authenticity of the employee. After all, it only takes one employee with a bad intention to destroy an organization. For example, the Barings Bank. And there are so many other examples that can cause enough stir to actually destroy the organization. Due process is another expression we use. Due process is about justice within the organization, fair treatment. Professional negligence is another big issue, etc. These are legal expressions. What does reasonable duty of care mean? It is a legal obligation on an individual who is required to demonstrate standard of reasonable care to avoid carelessness that could foreseeably harm or loss due to negligence. There must be a duty of care. There must be a duty. There must be a breach of duty. There are also reasonable proximity between the sufferer and the defendant as legal proximity. It is known as legal proximity. Reasonable duty of care is a responsibility to take care of others, not to cause harm or loss to others. Employees must take care. Employees must take care not to harm others, not to cause injury or harm to others, which also includes yourself. We have to take care. That's the duty of care. We have a duty towards others. We have a responsibility towards others. That's what I call reasonable duty of care. An extremely powerful legal expression. Remember, reasonable duty of care. Teachers have a legal responsibility, so do doctors have, and so do lawyers have. Also, architects have a legal responsibility. They must do their jobs. Otherwise, they may fall into the trap of professional negligence. Negligence means that someone has omitted to do something, and as a result, someone else suffered harm or loss. There was a duty, and a breach of duty has taken place, and that's why there has been a loss or harm to somebody. And what I have stated is from a non legal perspective. It's a huge topic. Remember, the tort of negligence is a branch of law which actually deals with negligence. It's a huge topic on its own and very interesting. What is due process? This means, very simply stating, fair treatment. Discrimination refers to where one receives unfair treatment because of who you are. In United Kingdom, there are 9 protected characteristics, and if one of them are violated, discrimination has taken place. What are those 9 characteristics? Protected characteristics. Age, you cannot discriminate somebody based on age. Of course, minority is an issue. Minority, we don't actually employ minorities below the age of 18. Different countries have different laws. But yes, age is a big issue. Disability, without reasonable doubt, reasonable without reason, we cannot discriminate somebody. For example, in the security service, we need people physically fit. You need to justify the causes of discrimination. The causes of discrimination needs to be justified. Gender, you cannot discriminate based on gender. Is extremely powerful message to the whole world. Male and female are both the same. Having the same skills, ability, you cannot actually discriminate between both. Race, you cannot discriminate based on race, religion or beliefs, sex, sexual orientation. Remember, I'm talking from the context of United Kingdom. And I have come to the end of this episode. The topic is huge and may not have done justice to the topic. I know I haven't done justice to the topic of law because it's such huge, it's enormous. But the objective in this episode was to grow some awareness related to legal framework we work within as HRM professionals. So, my friends, stay well wherever you are, stay calm, stay happy. I'll meet you soon, very, very soon. Take care, my friends. Bye bye.